Hi everyone. Today in this lecture, we are going to complete the general meetings in the Super 35 batch. Next, we are going to start with FEMA. So anyway, let us first start with question number 30. Question number 30 with regard to the question bank, please open that. We are going to do question number 30 first. Okay, let's begin. M Limited held its annual general meeting on September 15th, 2017. The meeting was presided over by Mr. Venkat, the chairman of the company's board of directors. On September 17th, 2017, Mr. Venkat, the chairman, without signing the minutes of the meeting, left India to look after his father who fell sick in London. Referring to the provisions of Companies Act 2013, examine the manner in which minutes of the above meeting are to be signed in the absence of Mr. Venkat and by whom. Mark it very important for the J25 exam. Chance is there, this can come in examination. Please read the question, I'm making it full page. I request every one of you, please don't see the answer. Read the question first, understand the facts, what is happening. Okay, now, please read only the question, not the answer. Be honest in reading it. Okay, read the question. I will give 2 minutes time. Read the question. Read 2-3 times. Then you will understand the intricacies inside it. Okay. Now, whenever question is given on minutes, whenever a question is given on minutes, what we need to write in exam? Whenever question is given on minutes of 5 marks, first write down what is minutes. Minutes is summary of fair and correct. Fair and correct or true and correct. Summary of proceedings at a general meeting. Number two, whenever minutes are to be prepared, minutes should be prepared within 30 days. Within 30 days. Within 30 days. Once the meeting is completed, within 30 days from the conclusion, okay, from the conclusion, you need to prepare the minutes. Sir, in the meeting, what we will do, listen carefully. This you need to understand. Minutes will be roughly drafted by company secretary in the meeting, but it will be made fair. It will be made fair and perfect within 30 days. Roughly, he will write, but that should be fair by the chairman. Okay, company secretary will sit with the chairman. He will read out. Company secretary will read the minutes what he has written. Chairperson will listen to all the things what he said. Finally, he will tell, please not to include these like that. They will include or exclude certain things and finalize the minutes. Okay, so that should be done within a period of 30 days from the conclusion of the meeting. That point you need to write. Next one, signing. Two things. Where to sign, whom to sign. Is the question. Where to sign? Each page of minutes book, last page of minutes book. Each page of minutes book can be initialed or signed. What do you mean initial? Kaushik Mukesh. Just write K and leave. Or put the full signature. Kaushik, you can put. This is initialed, this is signed. Last page must be dated and signed. Dated and signed. Each page of the minutes will be initialed or signed. Last page of the minutes book will be dated and signed. Okay, who should sign that? Chairman of the same meeting. Chairman of the same meeting within 30 days. Okay, if this chairman of the same meeting is not available by any reason, in that case, any kind of director authorized by the board, authorized by the board. All the board of directors decided this person will sign, that person will sign in the minutes. Okay, not the chairman of the succeeding meeting. Okay, don't write like that. If chairman is available, that chairman will sign. If the chairman is not available, okay, any director authorized by the board of directors, any director authorized by the board, 10 directors are there, all 10 decided that Mr. A will sign, he will only sign. Okay, see here. See here. M Limited held its AGM on 15th September. Meeting was presided over by Mr. Venkat. It is a chairman. Okay. On September 17, 2017, Mr. Venkat, the chairman, without signing the minutes of the meeting, left India to look after his father who fell sick in London. Referring to the provisions of Companies Act, examine the manner in which minutes of the above meeting should be signed in the absence of Mr. Venkat and by whom. Okay. So first you have to write the provision. As per section 118, every company shall prepare and keep the minutes of every annual general meeting. Okay. That you have to write. Next one. The minutes will be kept as a evidence. Point 2. Next one. After that. As per the rule 25 read with section number 1118, each page shall be initialed or signed. Last page shall be dated and signed in case of general meeting by chairman of the same meeting, okay, within 30 days. In the event of death or inability of the chairman, by director duly authorized, not by a person. In exam they may twist a question saying that the board of directors wanted to authorize, okay, board of directors wanted to authorize company secretary to sign on the minutes. Can he? No, because director authorized by the board only. For example, 10 directors are there. I told you the example that 10 directors, one director can be authorized. Okay, 10 directors cannot authorize a normal person not being a director. They cannot do that. Therefore, the minutes of the meeting, conclusion. Therefore, the minutes of the meeting referred to in the given case above it shall be signed either by Mr. Venkat in the absence any director authorized by the board. For this, they gave for 5 marks. Again, chance is there, it can come. See how many times they tested. Previous paper, Jan 21 also they gave. Okay. This is the question and answer. Next. Bazaar Limited called its AGM to lay down its financial statement for the shareholder due to the want of quorum. The meeting, this was already covered. A repetitive question. Means what? That was given in exam, this was given in mock test. Next. Kambu Limited, so this is the MTP RTP question. Kambu Limited was incorporated on 1/4/2018. Company did not have much to report to the shareholders. So, no general meeting of the company has been held till 30/4/2020. The company has recently appointed a new accountant. The new accountant has pointed out that company required to hold the annual general meeting. The company has approached you, a senior chartered accountant. Please advise the company regarding the time limit for holding the first annual general meeting of the company and the power of registrar to grant extension of time for the first annual general meeting. Read the question. Good question again. Make it full screen. 2 minutes time. Read the question properly. Okay. So let us read one last time. Jambu Limited was incorporated on 1/4/2018. The company did not have much to report to its shareholders, so no general meeting of the company has been held till 30/4/2020. The company has recently appointed a new accountant. The new accountant has pointed out that company required to hold AGM. The company has approached you, a senior chartered accountant. Please advise the company regarding the time limit for holding the first annual general meeting and the power of ROC to grant extension of time. Okay, listen first. First annual general meeting of the company is mandatory. It's not about whether there are more things to report, less things to report, whether it is there or not. It's a statutory obligation to conduct the first annual general meeting and file your financial statements annual return with the ROC. It's the obligation. Obligation key, whether it happened, not happened, that will not be there. Understood. So whenever in our family, when there is any important function or a marriage, etc., we go and give the card. Please attend the function. Correct or not? They said we are not going to come because we are having another function. What you will do, you will take back the card. Ah, okay, then give it back. Waste of time for you. So it's a formality. Yeah, whether they come or not, you have to give. Whether transactions are there or not, you have to conduct first annual general meeting. Attend and tell that there are no transactions. At least do that. So, first point number one, the company's contention of not holding the AGM because there are nothing to report is not a right thing. That's the one answer. Let us now come to the time limit for holding the first AGM. The first AGM of a company must be held within, okay, should be held within 18 months of the date of incorporation. How many months? 18 months. Technically, people don't call it 18 months. I will tell this way. It should be held within 9 months from the closure of the first financial year. 9 months from the closure of first financial year. So I repeat one more time. Whenever you wanted to conduct a AGM, first AGM, it should be conducted within 9 months from the closure of first financial year. Old one is a 18 months from the date of incorporation. That was not there now. So don't write that answer because in some of the scanners I found that answer also. Okay, 18 months from the date of incorporation is the old provision. Now that was not there. Now the provision is first AGM must be held within 9 months from the date of, 9 months from the closure of first financial year. Okay, you must conduct the AGM. See here now. When this company got incorporated, 1/4/18. Financial year 18/19. 18/19 की last date 31st March 2009. Sorry. So, yes, 31st March 2019 plus 9 months means 31/12. Okay, 31/12/2019. This will be the last date for holding the first AGM. But the company has, but no general meeting has been held till 30/4/2020. Means company has complied with AGM or not complied. Company has not complied with AGM. There is a penalty for doing like this. Am I clear? So it is not according to the law. And moreover, registrar to grant extension. Can registrar grant extension? No. Granting extension will not be there for the first AGM. Extension will be available only for the subsequent AGM, second, third, fourth, fifth, like that. For the first AGM, there is no concept of extension. Clear? According to section 96, every company shall be required to hold its first annual general meeting within a period of 9 months from the date of closing its first financial years. Okay. First financial year will be closing on 31st March 2019. And first general meeting should be held within 31st December 2019. What I said. Section further provides that registrar may, for any special reason, extend the time of general meeting other than first AGM. Therefore, thus first AGM of Infotech should be held on or before 31st December. Registrar does not have any power to grant extension. Answer is over. Next one. Question number 33. P Limited had called its AGM on 30th August 2019. Mr. Pawan has filed a complaint against the company that he could not attend the meeting as the company did not serve the notice to him for attending AGM. The company in turn provided the proof that they had sent the notice by way of an email to Mr. Pawan inviting him to attend the AGM of the company. Mr. Pawan alleged that he never received the email. In the light of the provisions of Companies Act 2013, advised whether the company has erred. Erred means does it do any mistake in serving the notice of AGM to Mr. Pawan? Please read the question properly. Read it. When I ask you to read the question, read only the question. No answer. Read the question properly. Read it. Let me now explain you the concept. Can we send the notice by email? There are so many concepts covered here. First point number one. Mr. Pawan is a member. Okay. He filed a complaint that he could not attend the meeting because his notice is not received. Company said that we sent the email, sending proof also is there. But he said that I did not receive. But I did not receive email. That's what he said. Maybe both are right. Company sent, Pawan did not receive it. How to tackle this problem is a question now. You should see always as a professional here. Don't see it as a question answer. See it as a professional. When some problem comes onto your table, how will you see that? Okay, first point number one. How to present the answer. First point number one. Relating to the notice, you have to write the point. What is the point? Every company must send a notice of not less than 21 clear days before the meeting to all the members at their registered address. At their registered address, not registered office, registered address, their address. Okay. So of the whatever the registered address they have given, to that address, they have to send the notice of a AGM. Next, notice by way of email, whether allowed or not is a question. Rules said that notice by email is a perfect way of serving a notice. Okay. And moreover, not just meeting, not just notice is given by email. Now question will arise, sir, how my email company will know? That's why whenever the shares are held in a demat form, whenever shares are held in demat form, company will not send the notice. Company will give notice format to demat depository. Depository will send email to the registered email id you have given to the demat depository. There are the upstocks are there na? To them, when you open the account, you will give an email id. To that email id, depository will send if it is a listed company. In case of unlisted company, they will send an email to your email address whatever you have given. That's why every financial year one time, you will be given a chance. You will be given what's a chance to update your email address. Update your email address. You can update your email id and you can give it to the company or to the depository in case of listed companies, such that any communication will be made to that email. So at the end conclusion, notice must be given to every member at their registered address. Number one. Can the notice be given by email? Yes, notice can be given by email. It is a right way of communication. It is a right way of communication. There is no wrong in sending a notice that way. Number three, whenever you wanted to send a notice by way of an email, you should give a chance to the person to update their email ID at least once in a financial year. At least once in every financial year, you should give a chance to update. And you have to send the notice to that email. Very, very important next point. company's obligation of serving a notice. Everyone listen carefully. Company's obligation of serving the notice through email will be completed. Means company side obligation will be completed if transmission is over. If what is over here? Transmission is over. Receipt is not important. What is not important? Receipt is not important. If there is a email, if there is any email account problem with the receiver, what company can do? Sending is important. Okay, transmission is important. If you have the proof that you sent, enough. Whether it delivered that email or not, if there is any technical snag in the lines, that is not the headache of the company. In the given case, company has rightly sent a notice by email. Mr. Pawan did not receive it. Mr. Pawan did not receive it. Therefore, it's not the mistake of company. Company's obligation will be completed once it is transmitted. Clear. And moreover, whenever notice is not properly given, okay, whenever notice is missed, if any person do not receive, two concepts will come. Number one, the first one is accidental omission, deliberate omission. Accidental omission means what? We send, that does not receive you. Okay, deliberate omission means what? Deliberate omission means intentionally if they omit. In case of accidental omission like this, okay, no problem, nothing will happen, meeting will be valid. Deliberately if they omit to give a notice, then there will be a problem. Let us see. Very important big answer. Understand how to write. First, sending notice by electronic mode, e-mode, statutorily recognized. Statutorily means government wise it is recognized, legally recognized. Notice may be sent through email as a text. Okay, directly email you can put full notice. In the email you can type. Sir, email typing not possible, sir. It is 6-7 pages. Then send as an attachment. Or you can have a website. In that website, notice will be there. You can give URL or as URL, also called as an electronic link. Next, email shall be addressed to the person entitled to receive such email as per the records of the company as provided by the depository. If it is listed company. Also, company shall provide advance opportunity at least once in a financial year to the member to register email ID and to make some changes. All these things. In the light of above provisions of the Act, the company's obligation is satisfied when it transmits the email, and company shall not be held responsible for failure in transmission beyond its control. Also, if the member is entitled to receive the notice, fail to provide or update any relevant email ID to the company or depository participant, the company shall not be in default. Hence, the company has not erred in serving the notice of AGM to Mr. Pawan. Next question. 34. The Board of Directors of Swati Limited called an extraordinary general meeting upon requisition of members. However, the meeting was adjourned on the ground that quorum was not present at the meeting. Advised the company on the basis of the provisions of Companies Act 2013. Now let us see. Board of Directors of Swati Limited called an extraordinary general meeting. Okay. Board of Directors called EGM upon requisition of members. However, meeting was adjourned on the ground that quorum is not present. Whenever the quorum is not present, two situations. Meeting is adjourned for the want of quorum, and such meeting is called by the Board of Directors or Board of Directors upon requisition of members. In these two cases, what will happen? In these two cases, the meeting will be adjourned either as per the board decision or at the same day, same time, same place next week. Okay, this is one answer. If it is called by requisitionists themselves because board fails to call a EGM, in that case meeting will be cancelled. Okay. So the board of directors must convene a general meeting upon requisition of stipulated number of members. As per 103 2B, if the quorum is not present within half an hour from the time appointed, okay, if called on requisition, the meeting shall stand cancelled. I told you this question everywhere institute has given wrong answer. What wrong answer? I told you this is the fifth or sixth time same question came. All the time they are doing that. Actually, as per section 100, there are two types of EGM, three types of EGM. EGM called by board themselves, EGM called by board upon requisition of members, EGM called by requisitionists themselves. Okay, third one is different. Okay, if it is first two cases, and EGM either called by board sumoto or board on the request of members, in that case, the meeting will be adjourned to the same day, same time, same place next week, or as the board decided. But if the meeting is called by requisition is themselves under section 100, then only meeting will be cancelled. but they are giving cancellation for all kinds of EGM, whichever is called by the board on requisition of members. Means what? Board sumoto na board sumoto if it is adjourned. Sorry, board sumoto if the meeting original meeting is called, means without any requisition. Then adjournment is there as per ICA. And next, whether it is board called on requisition or requisition is themselves called, ICA answer is very clearly saying that it is directly taken as cancelled, but it is a wrong answer. I told you so many times, but still same answer again given. You can read it. 1 minute time I will give. You can read. Let us continue for the next one. 35. State with the reason whether the following statement is correct or incorrect. An annual general meeting can be held on a national holiday. Let us understand. AGM can be held on a national holiday. Is a question now. Actually, answer is no. AGM can be held on any day other than on a national holiday. Means, hello? Congratulations. అవునా? ఓకే. ఓకే. అన్న ఒక్క నిమిషం అన్న. ఒక్క నిమిషం నేను చేస్తాను. My close friend has called. He got a very big deal. Stock market deal. So, anyway, state with reason whether the following statement is correct or incorrect. An annual general meeting can be held on a national holiday. First point number one. Can it be held on a national holiday or not is a question now. Point is very clear. A meeting can be held on a national holiday or not. AGM should be held during the business hours at the registered office of a company, and that too during the business hours. Okay. So therefore, it is always allowed to conduct a AGM only on a only on a day other than a national holiday. Therefore, conclusion is very simple. AGM cannot be held on a national holiday. So AGM cannot be held on a national holiday. Under section 96, every annual general meeting shall be called during business hours 9 to 6 on any day which is not a national holiday. Okay. Thus, the statement an annual general meeting can be held on national holiday is incorrect. Next, a company should file its annual return within 6 months of closing of financial year. No, it should be held within, it should be filed within 60 days of the date of AGM. The statement is incorrect. State that every company shall file with the registrar a copy of annual return within 60 days from the date of its AGM is held. If AGM may not held, we already read reasons for not conducting the AGM, you have to file within 60 days from the last date on which AGM should have been held. Over. Next, 36. Nestle Limited has decided to conduct its AGM on 28th of September 2021. They have sent the notice of the meeting on 9th September 2021, for which they have taken the consent from 90% of the members entitled to vote thereat. Comment on the validity of the AGM as per the provisions of Companies Act 2013. It's a question that is being asked. Okay, so let us try to understand it clearly now. Read the question first before we go into that. Read the question properly. Read. Now, see here. What is this concept talking about? This question is based on logic of shorter notice. Now notice here, shorter notice is the logic of this particular question. Let's have a clarity on this. Shorter notice means what? Generally, first you have to write the main provision. As per section number 101, every company shall call any general meeting, that annual or EGM. Every company shall hold a AGM or EGM or general meeting by giving not less than 21 clear days notice. How many days? 21 clear days notice. By giving not less than 21 clear days notice, it has to conduct a AGM. Means what? The gap between the general meeting and the date of your notice must be at least 21 clear days. Okay. However, sometimes emergency may come where I can't match that 21 clear days concept. In such a case, you can give a shorter notice, but you cannot conduct a meeting by giving a shorter notice unless in case of AGM, consent is given by, okay, consent is given by not less than 95% of the total number of members. Okay, not members holding not less than 95% capital illa. Not less than 95% of the total number of members. If in the company 10,000 are there, 9,500 people should consent either by post or by electronic means. They have to consent that we are okay with a shorter notice. Then you have to send the shorter notice at a lesser span and you can conduct a general meeting. I repeat one more time. Normally, notice of a general meeting must be given within not less than 21 days before the meeting. Okay, not less than 21 days before the meeting. However, a company may call a meeting by less than 21 clear days, provided it obtains the consent of, it accords the consent of not less than 95% of the total number of members in case of AGM. In case of EGM, majority shareholders means more than 50% in headcount has to say yes, holding not less than, okay, holding not less than 95% of the paid up share capital. Okay, majority la 50% should say, means 1,000 people attended the meeting. We are sending notice to 1,000 people, or in our company 1,000 members are there. 1,000 la more than 50 means a 501 should say yes. Okay, 501, 601, 701, minimum 501 should say yes. And that who said yes, na, those persons should hold not less than 95% of the capital. Both conditions should be satisfied in case of EGM. AGM that will not apply. Not less than 95% of the total number of members should say yes for shorter notice. Then you can give a shorter notice and conduct a general meeting with a time period lesser than 21 clear days. This is the answer. Okay. In the given case, what happened? Taken the consent from 90% of the members. Okay. No, wrong. 90 you should not take. You should take 95%. First provision. To whom you should give notice? To a member. Okay. If he die, legal representative, deceased member. If he is insolvent, official assignee he should give. As per section 101 states that to properly call a general meeting, notice of at least 21 clear days before the meeting should be given to all members. Legal representative, deceased member, assignee of the insolvent members, auditors and directors. Generally, general meetings need to be called by giving not less than 21 clear days notice. However, a general meeting can be called after giving shorter notice than that specified in the subsection if consent in writing is accorded thereto in case of AGM by not less than 95% of the members. In the given question, AGM was called by giving less than 21 days clear days notice. Also, consent for calling the meeting is given only by 90%, hence such meeting cannot be validly called. Whatever I said is there. And this concept, this question, ditto already we saw in one of the exam question also it came. Covered this. Next. Next. Let us see the question now. Okay. I don't know how to spell this. Sir HJ. Like that we will call. Sir HJ, a shareholder, gives a notice for inspecting the proxies. Gives a notice for inspecting the proxies 5 days before the meeting is scheduled and approaches the company 2 days before the scheduled meeting for inspecting the same. What is the legal position relating to his actions as per provisions of Companies Act? This is the question that is being tested. Okay, let's read the question first before we go into answer. Read the question. Okay, completed reading. Okay. Now let me first explain the provision and then the answer. First, you have to write the legal provision. I will explain the legal provision. See here. This is date of general meeting. Okay. Whenever proxy forms are deposited with the company, members will send proxy. But what is the proof that really he is a proxy appointed by a correct member? Therefore, proxy is always supported by a form called as a proxy form. Whenever there is a proxy form, it's a proof that really you are a proxy to him. One point over. Second point. Whenever proxy forms are deposited with the company, any member who is having a right to attend and vote, listen carefully. Every member don't have a right to inspect the proxy. A member who has a right to attend the meeting and vote thereat. Certain members will be there. Those members don't have a right to attend the meeting. They are members, say, but they don't have a right to vote. Okay. So why they will not have a right to attend the vote, or a right to attend and vote? Already we completed one concept that way. Okay, whenever there is a non-payment of calls or lien on the shares, you will not get voting. Such kind of persons can't inspect. Who can inspect? Only such members. So who has a right to attend the meeting and vote on any resolution there? Such members can make inspection of proxy forms lodged with the company. This is one point. Okay. Next. So how when they can inspect? They can inspect. Okay, they can inspect 24 hours prior to the meeting till the conclusion of the meeting. During this period to this period, inspection is possible. Okay, but one day before, 24 hours before, okay, 24 hours before or 22 hours before I came. Okay, that means you can inspect 24 hours before, 22 hours before, 10 hours before, 5 hours before, 1 hour before. Meeting also you can do, including conclusion time also you can make inspection, but not thereafter. Okay, and you can't inspect during this time. Okay, next. And moreover, whenever you wanted to make an inspection, directly you should not come to the meeting 24 hours before and tell I want to inspect. You should first tell the company I am going to come 10 hours before, 12 hours before, 20 hours before, 24 hours before, 25. Anyway you cannot tell. Like that you should first intimate. How many days before I should intimate? 3 days before you should intimate that you are going to make inspection of the proxy form, not more than 24 hours before the meeting. Two conditions you have to satisfy in this question. 2 days before the scheduled meeting, he wanted to inspect. Permitted, not permitted? Not permitted. Read now. Read this answer. Whatever I said will be there. Please read the answer properly. Completed. Next. Next one. Let us see the next question. Examine the validity of the following statement with respect to the AGM. The first AGM of a company shall be held within a period of 6 months from the date of closing of first financial year. Wrong. First AGM should be held within 9 months from the closure of the first financial year. The registrar may, for any special reason, extend the time within which the first AGM shall be held. No. The ROC has no right to extend the first AGM time. Already we read this. In 9 months, one answer. And moreover, registrar cannot. Registrar cannot extend. Next one. MTP and RTP. Amar, a director of Gokul Electricals Limited, gave in writing to the company that notice for any general meeting and of the board of directors meeting be sent only by registered post at his registered residential address at Kanpur, for which he deposited sufficient money. The company sent a notice to him by ordinary mail under certificate of posting. Amar did not receive this notice and could not attend the meeting and contended that notice was improper. Decide as per the provisions of Companies Act whether contention of Amar is valid. Will your answer be same if Amar remains in USA for 1 month during which notice of the meeting was served and meeting was held? Very, very important question. Jan 25 can another expectation. When I say expected question, please be honest. Read the question 2 times. Okay, I will give time. Read the question 2 times. Completed reading the question. Now, read the question. Let's continue. See here. Here the question is based on General Meetings chapter and section 20 in the Incorporation chapter. Listen, first I will explain the concept. Whenever we have to serve any document on any ROC or member, I repeat one more time. Whenever you wanted to serve any notice on ROC or member, that means whenever I wanted to communicate, company wanted to communicate with ROC or company wanted to communicate with a member, how to communicate? They can communicate either by post or by registered post, okay, or by certificate of posting or by speed post or even by email. Like that, they can communicate, okay. They can company can give a notice to the ROC or any member in any of these ways: post, registered post, okay, or speed post or in electronic mode. They can give the notices to members, okay. However, if any member specifically request, the company, then only by that means then they have to pay some money to the company in advance. AGM la shareholders will decide how much to pay. You have to pay that amount in advance to the company, then company must give you the notice only in that mode at that place. Am I clear or not? So mode of giving the notice to a member can decide. But for example, company if they send email, no cost. But if it has to send a registered post with a certificate of posting, it costs somewhere around 200-300 rupees for the company. Therefore, whenever company chooses email, it's because it's easy and fast. But a member said that I don't have a email, or I have email but I don't see it on phone very often. Therefore, I may miss your notice. Therefore, send it by a notice physically by registered post. If he say, we will send. But the 200 or 300 every time you give it in advance to the company, we will send it. In question. But what happened? Let us see. Amar, a director of Gokul Electricals Limited, gave in writing to the company that notice for any general meeting and of the board of directors meeting be sent to him only by registered post, clearly, at his residential address at Kanpur, for which he deposited sufficient money also. Company sent a notice by ordinary mail under certificate of posting. He did not receive the notice and could not attend the meeting. Yes. Notice was improper? Yes. I paid the amount and I said, please send it to the Kanpur to my residential address only by registered post. For that, I deposited money. Company is at an obligation to send only by registered post. Ordinary post, it cannot send. Okay. So, contention of Amar is valid? Valid. If Amar is in USA, will your answer change? Even if you are in USA, we will send only to Kanpur in residential address. Okay. Residential address is important, not where you really resides at that time. See the answer, complete it fast. Let us move on to the next question. Kurt Limited is a company engaged in the business of manufacturing the papers. The company has approached you to explain them the following as per the provisions of Companies Act. Quorum for the general meeting, if the company has 800 members. 0 to 500, 0 to 1000, it will be, if it is a limited, public limited company, 5 members personally present. Personally present means it will include only members, not the proxies. If the company is having 6,500, it is not 1000 to 5000, it is more than 5000. 30 members personally present. Quorum for the general meeting, if the company has 5,500, the articles of association has prescribed quorum to be 50. Can articles provide for a larger quorum? Yes. The first part of the section in quorum itself will tell, unless articles provide for a larger quorum, this will apply. Okay. Generally for 5,500, okay, generally for 5,500, it is 30 members. But articles provided for larger now follow articles only. 50 members personally present. Come the quorum. First write the provision. After that, members personally present, okay, members personally present will be entitled to vote. If the company has 800 members, 5. If the company has 6,500, 30. If company has 5,500, 30, but However, since articles prescribed quorum for the meeting to be 50, quorum shall be 50 only, higher of 30 and 50. Next question. Articles of Association of ABC Limited require personal presence of 7 members to constitute a quorum. Limited, public limited, 7. Articles can provide for a larger quorum or not? Yes, they provided for 7 as a quorum in a general meeting. The company has 870 members as on the date of meeting. Okay, 870 members means it is that limit is up to 1000. So therefore 5 personally present, but articles provided for 7, 5 or 7, whichever is higher, 7 has to be taken. Okay, the following persons were present in the extraordinary meeting to consider the appointment of managing director. Next, A. The representative governor of Karnataka, as per section number 112, as per section 112. There is a section called as section number 112. As per that particular section, whenever the shareholders of the company are governors of a state, they need not appoint a proxy, they will appoint a representative who will have all the rights like a member. Okay, and moreover, that representative can appoint proxy again. Okay, so representative is not a proxy. Representative will be treated as a member and he will have all the rights like a member. Okay, okay. A, the representative governor of Karnataka. Okay, he will be treated as one member. B and C shareholders of preference shares. Members, preference member also counted. 2. D, representing green limited, blue limited. Okay. If there are body corporates, then body corporates are governed by section number 113. Body corporates means company is a member in another company, but company can't go to the meeting and they will appoint representatives, not proxy. Already we read this concept in one of the previous questions. Okay. So green limited ki D is there, blue limited representing D. So 2 representations are there. Okay. EFGHR proxies not counted. Not counted. So here 2, 2, 1. How many are there totally? 5 personally present. Normally okay, but here we require 7. Therefore, quorum is not present. First, you have to write the main point here. 7 members personally present, higher of 5 and 7. Next, only members present in person, not by proxy, are counted. If a company is a member of another company, it may authorize a person to act as a representative of the latter company, then such person shall be deemed to be a member. That's what I said. Okay, present in person counted for quorum. Same, president and governor also same provision. They can appoint representative, may not be proxy. Representative has all rights of a member, like that representative can appoint a proxy. Okay, next. A will be included for the purpose of quorum. B and C have to be excluded for the purpose of quorum because they represent the preference shares. Is the answer given by the ICA. But in reality, they use the word members. They did not use the word equity members. Any member can be counted. But here, they are not taking preference shares. Reasoning, I will tell you why. Okay, why preference shareholders are not considered in this example. Actually, preference shareholders will also be treated as members for the purpose of quorum. But in this question, answer will not change anyway. We require 7, but we have only 5. Quorum is not present. 2 answers you can write. Preference shareholders B and C are there. You can write one answer. Preference shareholders are also members, therefore they can be counted for quorum. However, answer given by ICI is more correct. Do you know why? I will tell you. Preference shareholders will not have a right to vote. They will have right to vote only if any matter is affecting their rights. Here, appointment of MD does not affect their rights. Therefore, ICA has written the answer. We will not consider them. That is also right answer. Okay. If you remove them, 5 become 3 only. So B and C have to be excluded. Since the agenda is appointment of MD, their rights cannot be said to be affected. That's the reasoning they have given. He will have 2 votes. I told her he is representing Green and Blue Limited. Okay, EFGH will not be included. Thus, it can be said the requirement of quorum has not been met. Next one. Happy Limited received a proxy form. 54 hours before the time fixed for the start of the meeting. The company refused to accept the proxy form on the ground that articles of company provided that a proxy form must be filed 60 hours before the start of the meeting. Define a proxy and decide under the provisions of Companies Act 2013 whether the proxy holder can compel the company to admit the proxy in this case. Read the question first. Read the question, please. Get the point? Okay, let's continue. See here, section number 105 of section 1 of, by the way, first I will explain. Happy Limited received a proxy form 54 hours before the time fixed for the start of meeting. The company refused to accept the proxy on the ground that articles of the company provided proxy must be filed 60 hours before. First, let me tell the provision. Generally, proxy form has to be deposited with the company. Okay, deposited with the company at least 48 hours before the meeting. At least 48 hours before the meeting, and then technically 2 days before. Okay, that means member can voluntarily on his own, he may give 2 days before, 3 days before, 5 days before the meeting also, he can deposit a proxy form. Okay, but company should not compel any member to deposit the proxy form at time more than 48 hours. Act said that meeting and deposit of proxy form 48 hours gap should be there minimum. Member voluntarily can give 50 hours before, 54 hours before, 70, 80 hours before also you can give, but company should not compel. Maximum as per law is 48 hours before the meeting all proxy forms must be deposited with the company. Okay, articles, like, even though, listen carefully to this point, even if the company's articles said that proxy forms should be deposited for a time more than 48 hours, it shall be read as if it is 48 hours. Even though articles asked for more than 48 hours, we will read it as if it is 48 hours. So therefore, 54 hours before the meeting is a perfect lodging of a proxy form. Even though articles provided for 60, 54 will be valid because it was sent 48 hours before the meeting. Okay. Then define a proxy. Who is a proxy? Listen. Every member entitled to attend and vote thereat. Repeat the answer. Every member entitled to attend a meeting and vote thereat can appoint another person, may or may not be a member, can appoint another person to act as his proxy and to vote thereat. Any member of a company entitled to attend and vote at a meeting shall be entitled to appoint another person, that's all, he need not be member, as a proxy to attend and vote at the meeting on his behalf. Further, section 105 subsection 4 of the act provides that a proxy received 48 hours before the meeting will be valid even if the articles provided for longer period. In the given case, company received proxy form 54 hours before the time fixed for the start of the meeting. Happy Limited refused to accept the proxy on the ground that it should be sent 48 hours. Final answer. Proxy holder can compel the company to admit the proxy. With a view to transact some urgent business, Ratna, Rimpi, and Ratnesh, the three directors of Shilpkar Constructions Limited, okay, are desirous of calling a general meeting of the shareholders by giving shorter notice of 21 days clear note, shorter notice than 21 clear days notice. The fourth director, Nilesh, is of opinion that such an action will attract penalty provisions since there is a contravention. The paid up share capital of the company is 30 crore, divided into 3 crore shares of 10 rupees each. Keeping in view the applicable provisions of the Companies Act, discuss the possibility of calling a general meeting by giving a shorter notice. Read the question properly. Read reading everyone. Okay, let's continue. First, Already I told you. Generally, notice of a general meeting must be given not less than 21 clear days before the meeting. That point you have to write first. However, you can also give a shorter notice. Okay, divide into two parts. One is AGM and second one is EGM. So the first one is AGM and the second one is EGM. So AGM of a company will be held. You can give a shorter notice for the annual general meeting of a company, provided one condition is satisfied. That is, the number of members, the number of members not less than 95% of the total number of members must consent for the shorter notice. Must consent for the shorter notice. That's the first condition. So, whenever you wanted to give a shorter notice for the AGM, not less than 95% of the total number of members should say yes for that shorter notice, either by post or by electronic mode. They have to say yes. Then only you can give a notice, shorter notice, and conduct a general meeting. Number two, if it is a EGM, two conditions. Majority members holding not less than 95% of the paid up share capital should say yes. Okay, here if you see the question, okay, if you see the question here, if you observe the question, they just said that it is a, see here, they just use the word general meeting. Whether this is a AGM or EGM, there is no clarity. There is no clarity with regard to whether this is a annual general meeting or extraordinary general meeting. Therefore, we have to give the answer for both the sides, whether it is AGM or EGM. How the answer will come, we need to give both. Normally, general meetings are to be called by giving at least 21 clear days notice as required by section number 101. As required by section number 101. Okay. An exception is in the first proviso said that you can give a shorter notice if the consent in writing is obtained in consent in writing or by electronic mode is accorded. In case of annual general meeting by members holding, if the company has a share capital majority in number of members holding entitled to vote and who represent not less than 95% of the paid up share capital of the company, that gives the voting right. If the company has no share capital, not less than 95% of the total voting power. This is other than annual general meeting. If it is an annual general meeting, then it will be not less than 95% of the total number of members. Here clarity is not there. Therefore, you can write both the answers. Okay, you can write both the answer. But institute has assumed only EGM. Since nothing is said, they consider it as EGM, not as a AGM. So if it is a EGM, they have to conduct a EGM. If it is a shorter notice, by majority in number and representing not less than 95% in the paid up share capital. That's it. Okay. So lastly, in the view of above provisions, Shilpakara Construction is permitted to call requisite general meeting by giving a short notice. However, members holding at least 95% of the total paid up share capital, which gives them right to vote, must give the consent. Okay. The answer. Next, 45. Mr. Krish, a shareholder of ABC Limited, has made a request to the company for providing copy of minutes book of general meeting. His name is already entered into the list of members of the company. Whether Mr. Krish is entitled to receive a copy of this particular minutes or not. So the question is asked on whether the member has a right to inspect the minutes book or not is a question now. Am I clear or not? So, but the answer is very simple. Directly you can see and tell. So, as per 119 section, any member shall be entitled to be furnished within 7 days after he has made a request. Means first you need to make a request for a copy of minutes book. Within 7 days, they will give you the minutes book to you. Okay. With the copy of any minutes of a general meeting on payment of such sum. Mr. Krish in the given case is the member of ABC Limited. So shall be entitled to receive a copy of minutes book of general meeting. Next. Next one. Ganges Limited, a listed public company, conducted its annual general meeting on 31st August 2022. However, 10 days have passed since 31st August 2022, but it has still not filed a report of annual general meeting. Accountant of the company has approached you for the advice regarding the same. Okay, see here. Minutes is different, report is different. What is different? Minutes is different, report is different. Minutes will be prepared and kept within the company. Listed companies has to maintain a report of AGM, same like a minutes. Okay, all some important things happening, when it was conducted, when notice was given, how many members attended, how many voted in favor, how many voted against, whether any director's appointment was made during that time or not. All these things they will do in that particular thing. Okay, listen carefully. Like minutes, report of AGM also should be filed. Minutes is not filed. Minutes will be signed by the chairman. But report of AGM has to be filed with the ROC within 30 days of the conclusion of AGM. Here only 10 days have been passed. So no problem. You can have extra 20 days. Okay. Listed company. Anyway, since Ganges is a listed company, hence it has to file the copy of report within 30 days. 30 days from 31st August. 10 days concept will not affect you. In the general meeting of Alpha Limited, the chairman directed to exclude certain matters detrimental to the interests of the company from the minutes. Mukesh, okay. A shareholder contended that minutes of the meeting must contain fair and correct summary of the proceedings. Decide whether the contention of Mukesh is maintainable. But surprisingly, contention of Mukesh is not correct now. Do you know why? Chairman has an exclusive right to take a decision as not to include certain matters, okay, which he reasonably felt that it is defamatory of any person, it is detrimental to the interests of the company, or if it is irrelevant or immaterial. Okay, in that case, chairman has exclusive discretion to exclude the matters from the minutes. Same answer we already read. I don't want to waste time. Next. Primal Limited is a company incorporated in India. It owns two subsidiaries, Privy Limited, which holds 75% shares, and Malvi Limited, a wholly owned subsidiary. Okay. Primal Limited is a company incorporated in India. It has two subsidiaries. One is a Privy Limited, 75% holding. Malvi Limited, wholly owned subsidiary. Both subsidiaries are incorporated outside India. The board of directors of Primal Limited intends to call EGM of Primal on urgent basis. Advise board of directors to call EGM to be held in India, EGM to be held in Netherlands. Let's see the question first. Read the question before we go to solution. Please read the question. Okay, done. Let's go to the answer. Generally, what they say is board of directors may, whenever they want, they can call a EGM. That's the first point. Next, if they wanted to conduct EGM, you must conduct EGM at any place within India. Need not be registered office or place of registered office. Wherever you want within India, you can conduct. But exception was given only in one case. If there is a wholly owned subsidiary incorporated outside India, two conditions should be satisfied. First, it should be a wholly owned subsidiary like Malvi and incorporated outside India. In such case, you are allowed to conduct EGM even outside India. Okay, so two answers now. In India, EGM can be held up? Yes. In India, EGM can be held for all the three companies. But outside India, Netherlands, you can conduct a Primal Limited general meeting. You can't conduct outside India. And Privy Limited also you can't conduct because it's not a wholly owned subsidiary. Only for Malvi Limited, you can conduct the EGM even outside India because it's a wholly owned subsidiary incorporated outside India. Can call EGM within India. Cannot call EGM of Primal Limited outside India. Mr. Pink held 100 partly paid shares of Red Limited. The company asked him to pay the final call money on the shares. Due to some unavoidable circumstances, he was unable to pay the amount on the call money to the company. At a general meeting of the shareholders, chairman disallowed him to cast the vote on the ground that articles do not permit a shareholder to vote if he has not paid any calls, etc. Simply, we already read this. Just now also I said 15-20 minutes back. Articles of association of the company, if it contains the restriction, then a member who do not pay the call money is not entitled to vote at the general meeting. Same concept. Therefore, at the meeting is sorry. Therefore, the chairman at the meeting is well within its right to refuse him to right to vote and Mr. Pink's contention is not valid. So he cannot attend and vote. Chairman is right in stopping him to vote. Last. 50 questions my target. 50 questions. We have 50th question we are going to complete now. Rizwan Limited, a listed company, is in the business of garment manufacturing and has registered office in so and so place in Rajasthan. The company has called its 6th annual general meeting at 3 p.m. on 22nd August, one day after my birthday. Okay, 23rd my birthday, 22nd meeting at Ansal Plaza, Bhiwadi. Some of the members of the company have opposed to calling the meeting at Ansal Plaza. The company has approached you to advise them in this regard. Suppose Mr. Rizwan Limited is an unlisted company and wants to call their 6th AGM at Jaipur. Will your answer differ? Read the question before we go to the solution. Read the question first. Okay, completed reading the question. Now see the question first. Here, this is a listed company. Okay, what is the significance of listed company? First, I will tell you. Whenever you wanted to conduct an annual general meeting, notice must be given to all the members, and meeting must be held during the business hours and not being a day which is a national holiday. At the registered office only you have to conduct AGM. If by any reason registered office is not capable to accommodate the number of members, then what you have to do? Then you have to conduct at any other place where the registered office is situated. Okay, for example, in the same city, town, or a village where the registered office is situated, other than at a registered office, some other hotel, auditoriums, etc., you can take and you can conduct. Therefore, this particular Rizwan Limited is a listed company and it has its head office, registered office is in Bhiwadi. Company called it 6th annual general meeting at Ansal Plaza, Bhiwadi. It's not in Hen Tower, it is in Ansal Plaza, but within the same city or town or village, na, so allowed. However, next. Suppose Rizwan Limited is an unlisted company. What will happen? And it want to conduct in Jaipur. Means it's not even in Bhiwadi. Now listen carefully. In case of a unlisted company, there is one exception. In case of a unlisted company, with the consent of all the members of the company, not 95%, 100% majority holding 95, all the members of the company, if they consent, in case of unlisted company, AGM of a company may be held at a place other than registered office and other than the place where the registered office is held. So you can conduct. Simply a conclusion is, if it is a listed company and if the consent of all the members is obtained, you can conduct the AGM of that particular unlisted company at any place within India. The answer. Okay. So according to section 96(2), every annual general meeting of a company shall be called during the business hours between 9 a.m. to 6 p.m. on a day which is not a national holiday, as I said. And it should be held at the register office or other place within the city, town, or village. But annual general meeting of an unlisted company may be held at any place in India if the consent is given by all the members. Thus, in the first case, the company is rightful in calling AGM at Ansal Plaza because it is in Bhiwadi. In the second scenario, in case of unlisted company, AGM may be held at any place in India if the consent is given by all members in advance. Hence, if the consent is given, okay, or else. Next session, balance 50 to 75 questions I will complete, and general meetings will be completed in Super 35. After general meetings, we are going into FEMA. FEMA, I will definitely come up live. Okay. Because of schedules now, I'm recording whenever the time is permitting, but FEMA will come up live. Thank you very much. Prepare well for the Super 35. It will help you a lot. Thank you.